Judiciary Committee, and the first bill that we're hearing today is House Bill 572 relative to official oppression, and we'll call the prime sponsor, Representative Itza.
Thank you, Mr. Chair. Members of the committee, for the record, I'm Representative Dan Itza. I represent Rockingham County, District 9, Epping, and Fremont. The reason that I have brought this bill before you is, having watched events around the state, there have been occasions when, particularly using the broad definition, public servants have not performed that which is required of them by law. Applications returned within the requisite time period and such. There are unusual occasions where something a power is alleged which is not rightfully granted. I would say, first of all, that the amendments to Roman numeral I should be able to stand on their own. So regardless of what you do with Roman numeral II, I think that the changes to 1 ought to be carried forward. As to Roman numeral II, I've had some discussions with senators and Senate counsel, and I would be happy to work on an amendment that might put this in a position that the Senate could approve. One thing that has been discussed is the definition of a public servant. And I mean, in the first instance, the easy thing to do would be to limit it to those who are not subject to election, whom the voters or the citizens definitely have a direct power to express their pleasure or displeasure regarding. So that could be tightened up. Another thing that, in reading it over, is very open-ended in its nature is the last clause, or clearly inherent in the nature of his or her office. That is a subjective evaluation, and as such, it probably ought to be removed. We shouldn't. What a public servant ought to be doing should not be, when it comes to something like a criminal violation, a subjective evaluation. Now, if they're required to do something by law, that's pretty straightforward. Or if they're prohibited from doing something by law, that's pretty straightforward. So if you could consider amending it in that regard, I would greatly appreciate it. The other idea that was floated, since I'll give you an example from my district that really speaks to the nugget of the issue. There was a poor family whose house had fallen into disrepair, and they lacked the means to repair it. A local group, I don't know whether it was a church or just a civic group, raised the money and the means, material, to repair the building, but they had to get a permit. The building inspector at the time wouldn't issue a permit. Now, what everybody kind of knew in the back plane is that he had a friend who wanted to buy the property under condemnation. But you couldn't really connect those dots. You can't prove what's going on inside of somebody's head. And that's often the case with official oppression, is that it's too tenuous to connect the dots, or sometimes it's just because I can't. They just, a power. So if you, an idea that was floated was in certain things. I don't know if it's generic to this bill, and I know that the Senate has more latitude than the House does on what's generic, or germane rather. Requiring, for instance, if permits requested of the state or the town are not returned by the deadline they're presumed approved. That would be a simple way to solve the situation. It would deprive arbitrary handling of an issue and would motivate the public servant to handle the issue within the time limit prescribed by law. So that's another thing you can consider. I'd be happy to entertain any questions.
Thank you very much, Representative. Are there questions from the committee? I guess my only question is if you have language, suggested language in mind.
I will work on that. This has been in the last 15 minutes, so I know I don't have anything prepared.
Understood. Thank you very much.
Okay.
Representative Sword, understanding that there might be an amendment in the works.
Yes. Thank you, Mr. Chairman. I'll confess that when I signed up to speak, the room was about empty, and I didn't want Representative Itza to be by himself, but I'm sure there are many more that signed up, so I'll try to be very brief. What I thought I could add to this was, from my perspective as Vice Chairman of the House Judiciary Committee and also a representative of a very small town, Easton, population 250 up in northern Grafton County, 65% national forest, that I bring down here a much different perspective from a lot of people. When we get bills in judiciary, such as right-to-know bills, which have very strict rules that must be followed, or at least that's the hope, I can say to people honestly, if we had to comply with laws like this up north, you would never get any volunteers because we can't have attorneys attending every selectmen's meeting and such things as that. It's unnecessary and it would be very expensive. So when I see a bill like this, I compare it to the way we work up north, and I would say this is not necessary up north because we know each other there. The fact that we know each other, and our doings as town officials are known to all the neighbors, that provides the social control we need to prevent any unjust actions. But for further downstate, all you have to do is read Section B of the Union Leader, and you see some terrible things happening because government gets remote from the average citizen. And the average citizen is not tuned in as we are in our little small town of Easton. So that, to me, is a great difference that justifies passing this kind of bill. And I just wanted to express my support from that small town perspective.
Thank you very much, Representative Sword. Other questions for Representative? Seeing none, thank you very much.
Thank you.
Representative McGuire.
Thank you, Mr. Chairman, members of the committee. For the record, my name is Dan McGuire. I represent Merrimack County District 8, the towns of Allenstown, Epsom, and Pittsfield. Just very briefly, this is not a earth-shattering bill. It's pretty easy to read, pretty short. From my point of view, it just fixes maybe a little bit of a hole in this particular section of the law in the sense that right now there's only oppression, which is a misdemeanor. This adds a kind of a lesser category in sort of lesser circumstances, which is a violation. And so I think it gives a little bit more flexibility in terms of prosecuting those kind of problems, that you don't necessarily have to jump all the way to a misdemeanor, that you have kind of an intermediate step. So. And I think that's really all I have to say. It's not that, like I said, it's not that complicated.
Thank you, Representative. Are there questions for the Representative? I would just have an observation from the bill. In the first part, there's in fact a misdemeanor provision, but there's also a linkage between a benefit and
Yes.
of the actor and act or failure to act by the official. And in the second part, it's a violation, so lesser to some degree, but it also removes the benefit to that person.
Exactly. So it's more if somebody's acting capriciously for whatever reason, you know, and you can't necessarily say they're doing it to put money in their own pocket or they're doing it for what, you know, you don't have to worry, you don't have to prove necessarily they're getting some benefit or they're trying to harm somebody in particular. So in cases where it might be difficult to prove something like that, you still can say you're doing something wrong, and therefore there should be a penalty. You know, so.
Thank you very much.
Yeah. All right. Thank you.
Thank you. from the Attorney General's office.
Good afternoon, Mr. Chairman. Good afternoon, committee members. Thanks for letting me speak. Appreciate it. Our agency respectfully opposes this bill, and I'd just like to outline a few reasons why. I'd like to talk about paragraph 1 of the amendment first, the portion that reduces the charge from a misdemeanor to a Class B misdemeanor. As the way the statute currently is, it could be charged as either a Class A or a Class B misdemeanor. Our concern is that by changing the bill and just making it a Class B misdemeanor, you would take away the discretion of judges to impose in appropriate cases either an imposed jail time or a suspended or deferred jail sentence. And while those instances might be rare, there certainly could be a case where a judge might decide that sending someone to jail would be appropriate punishment, or at least having a suspended or deferred sentence hanging over that individual's head might be an appropriate sentence as well. So we think it would be prudent to leave that discretion to judges by keeping this as a misdemeanor and allowing the option for imposed jail or suspended or deferred jail time. The other issue we'd like to point out is we think that by taking that ability away, by taking the ability of judges away to impose jail time, it will decrease the deterrence value of the statute, because clearly there's more deterrence value to a public official knowing that he or she could be subjected to a jail sentence as opposed to just a fine. And so for those two reasons, we think it would make more sense to leave the statute as is, give judges the discretion to impose jail time in appropriate cases. I'd like to talk briefly about the second part of the amendment. I understand there may be a proposal to amend this, so my comments may be somewhat moot. Obviously, certainly if there's an amendment put forth, we'll certainly bring additional comments before you on that.
Well, we welcome it when that part of the bill is introduced. Thank you.
Thank you, sir. Our concern is that this essentially creates a new offense by eliminating an element that currently exists, which is the mental state of acting with a purpose to either benefit oneself or to harm another individual. And our view of that is that essentially allows it to be clear that a public official is actually acting with criminal intent as opposed to simply exercising his or her discretion in a difficult circumstance. And essentially what this violation level offense would do is take away that additional element and allow individuals to bring claims when they are simply unhappy with a public official's decision in a case, essentially criminalizing discretionary conduct. And that's our concern, that it will allow individuals to bring a charge under the criminal code whenever he or she is unhappy, and that will obviously engender additional litigation for all the parties involved, especially the state agencies, that they're going to have to go in and defend these charges. We sat down and just tried to think about some examples, and sometimes it's kind of hard in a vacuum to think of examples, but we thought of a couple. The definition of public official right now includes not only judges but jurors. So under this provision, presumably a defendant could bring a charge against a juror if he or she was unhappy with a verdict, either in a criminal or civil case. And that's the type of unintended result we think would be possible under this statute. Another example that we thought about is, looking at the language of the statute, a constituent might say if the legislature didn't show up for a vote, that he or she violated this provision of the statute because it's inherent in their duties to show up for votes. And so we just tried to look at different examples to think about how this statute might be used, kind of the unintended results of what might happen. And that's why our concern is that it makes sense to keep that additional mental state element to distinguish what are purely discretionary acts, decisions that officials make in their day-to-day duties, versus acts which are clearly criminal because they've acted with a purpose to benefit themselves or to harm another individual. And so those are the reasons that we currently oppose the bill in its current form. I'd be happy to take any questions if there are any.
Thank you very much. And I just want to make sure I'm pronouncing it right. Is it Strelzin?
It's Strelzin, sir.
Thank you.
Thank you.
Seeing none, thank you very much.
Thank you for your time. I appreciate it.
Chris Dornan.
Mr. Chairman and committee members, I'm Chris Dornan of Concord. I'm the chairman of Citizens for Criminal Justice Reform. I have the same concern about this legislation that the Assistant Attorney General just raised. Let me give you an example of how it might have been used if it were on the books now. Mike Delaney refused to join the class action lawsuit against what is being called Obamacare. A huge majority of one house of the legislature